The dust is starting to settle off of this week's oral argument about tariffs, and now we see the blunders and mistakes of the Solicitor General, Donald Trump's favorite appellate lawyer, John Sauer, in which he was caught effectively in a lie to the United States Supreme Court, a lie upon which he bases the power grab that allows Donald Trump as president to steal from Congress its core constitutional right alone to set tariffs and taxes. What is the lie? What's the blunder and the mistake that was made in the opening brief? I'm going to discuss it right here. The New York Times did a great job, but I heard it with my own ears when I listened to the oral argument. I heard a trapped and cornered, painted into a corner John Sauer, the Solicitor General, in response to questions by John Roberts, the Chief Justice, basically tried to get out from his problem. His problem being, if tariffs are considered to be taxes and revenue generating, his argument is dead. Then even the MAGA 6 on the Supreme Court, all the Trump appointed justices on the Supreme Court would vote against him, because that is a clear separation of powers problem. That's a clear core constitutional function under Article 1 of the Constitution for Congress. But if he tries to describe tariffs as only being quote unquote incidental to revenue generating, it's really policy making, it's really regulatory, it's really foreign affairs Article 2 power of the president to regulate, and revenue just happens to come in. If they buy that lie, that argument, then they could likely lead to uphold the tariffs. And the problem is that Roberts, who he needs as a vote, he effectively lied to, because it's inconsistent with what he wrote in his own brief, his own legal filing. Because in the legal filing, they talk about the public statements of Donald Trump about how this is revenue generating, and that it will save America from a depression, and it will save a dead country, and that trillions of dollars of revenue will come in. That doesn't make revenue incidental. That makes revenue the primary purpose of the tariff, meaning it is a tax, meaning it will die at the Supreme Court. It's a bonehead blunder by John Sauer. He tried to fix it. He was looking for any rescue operation he could. I'm going to play you a couple of clips, one by Amy Coney Barrett asking him questions, and one by John Roberts. I'm glad you're here. Hit the free subscribe button as we get into the bonehead move of the Trump administration and its Department of Justice that may lead to the death of the tariffs. And this is important because we all know that tariffs are taxes. I mean, we had JP Morgan do an analysis that the tariffs are being passed along to consumers at a 70% level, increasing their prices. Tariffs aren't paid by the countries that Donald Trump is trying to punish. It's paid by the importer in America with American jobs, who then passes it along to the consumer. Maybe not in the first quarter as they were trying to figure out tariffs, but subsequent to that. They brought it in later. And so it gets passed along later, as it is now. That is a tax. As Justice Sotomayor said during oral argument, it is a tax on the American consumer. But the blunder, I'm going to read to you from the brief that John Sauer filed, which painted him into a corner. He tried to get out of it, but not successfully with John Roberts. And then he thought he was being thrown another life preserver by Amy Coney Barrett, who I believe is firmly against the presidential having tariff power, when she tried to help him out, but really all she did was set a trap for him. Let's start with the clip from the oral argument this week of John Sauer being grilled by Chief Justice Roberts, and where he says he makes the lie. John Sauer says tariffs are incidental revenue generators. It's not their main purpose. Listen to this exchange.
But I mean, and I think this is a question for the other side as well. It's two-facing. Yes, of course, tariffs and dealings with foreign powers, but the vehicle is imposition of taxes on Americans, and that has always been the core power of Congress. So to have the president's foreign affairs power trump that basic power for Congress seems to me to kind of at least neutralize between the two powers, the executive power and the legislative power.
Let me say two things in response to that. First, the notion that the taxes are all borne by Americans and are not borne by foreign producers whose goods are imported is empirically, there's no basis for that in the record. It's actually a mixed.
Well, who pays the tariffs? If a tariff is imposed on automobiles, who pays them?
Typically there'd be regardless of who the importer of record is, there'd be a contract that would go along the sort of line of transfer that would allocate the tariff, and there'd be different. Sometimes the foreign producer would pay them. Sometimes the importer would bear the cost. The importer could be an American, could be a foreign company. A lot of times it's a wholly owned American subsidiary of a foreign corporation. So it gets allocated. The empirical estimates range from like 30% to 80% of like how much is borne by American
it's
citizens.
been suggested that the tariffs are responsible for significant reduction in our deficit. I would say that's raising revenue domestically.
There certainly is an incidental and collateral effect of the tariffs that they do raise revenue, but it's very important that they are regulatory tariffs, not revenue-raising tariffs. And the way you can see this, I think, if you look at this policy is by far the most effective if nobody ever pays the tariff.
Okay. Now, normally what the things that the president says isn't necessarily part of the record as the Supreme Court looks at powers outlined in the Constitution and provided by the Constitution. They normally just kind of look with blinders at, well, let's look at Article 2 powers for the president. Let's look at him in foreign affairs. Let's look at Article 1 powers for Congress. And let's look at the legislative history around that, except when the president happens to be Donald Trump and he can't stop talking and he can't stop bragging. And they include his quotes in order to satisfy him and appease him in their brief to the Supreme Court. Right in the the second page of the brief, in the introduction, in the first paragraph. This is what they say. Now remember, his argument you just heard, as he's trying to salvage it, is that the tariffs around the world, charges about goods being imported, the purpose of them is not to raise revenue, it's only incidental. Now listen to this bonehead blunder in their brief in the first paragraph. These consolidated cases address President Trump's lawful imposition of tariffs under the International Emergency Economic Powers Act, which the president, in his exercise of power over the military and foreign affairs, has determined are necessary to rectify America's country-killing trade deficits. To the president, these cases present a stark choice. Here comes revenue. With tariffs, we are a rich nation. Without tariffs, we are a poor nation. And in case you missed that it's revenue generating as it's at its core, John Sauer goes on to say, the president has stated that, quote, 1 year ago, the United States was a dead country. And now, because of the trillions of dollars being paid by countries that have so badly abused us, America is a strong, financially viable, and respected country again. Suddenly, revoking this tariff authority would have catastrophic consequences for, among other things, the economy. The president has made clear that if the United States was forced to pay back the trillions of dollars committed to us, America would go from strength to failure the moment such an incorrect decision took effect. Doesn't that sound like we want the money? We used it to generate the money? And if you're not convinced by that, there were plenty of statements that were made by people in his administration, including the Treasury Secretary, about how we got to keep the trillions. Let's play Scott Bessent and the Treasury Secretary.
Supreme Court were to go against the president on this. Are you confident that another route can be found to continue with the policy and not get into the morass of trying to be? I don't even know how it would work if you had to, start reversing some of the what we've seen with the tariffs.
Yeah, Joe, there are lots of other authorities that can be used, but IEPA is by far the cleanest, and it gives the U.S. and the president the most negotiating authority. And again, when we get something like October 8th, where the entire manufacturing ecosystem in the U.S. and the world was at threat of shutdown, then it's very important to be able to have these. The others are more cumbersome, but they can be effective, less it hinders the president's negotiating ability to be able to protect the American people and the American economy. So, this is very important tomorrow, and SCOTUS is going to hear this. And again, this is a signature policy for the president, and traditionally SCOTUS has been loath to interfere with these signature policies.
Now, that's a problem, because that argument in the brief opened the door to all of the public statements of the president touting the tariffs that were going to be used effectively to replace the hole in the budget and in the revenue generation of the United States created by Donald Trump lowering taxes for the rich. He had a hole he had to fill. So he's busy cutting things with Musk, all sorts of millions and billions of dollars of funding, and then raising money. In fact, you'll recall, and I'm sure the Supreme Court does too, that Donald Trump wanted to create an external revenue service to collect money from overseas instead of internally. Do you remember that? Here's a clip about external revenue service.
Instead of taxing our citizens to enrich other countries, we will tariff and tax foreign countries to enrich our citizens. For this purpose, we are establishing the External Revenue Service to collect all tariffs, duties, and revenues. It will be massive amounts of money pouring into our Treasury, coming from foreign sources. The American dream will soon be back and thriving like never before.
Now, John Sauer knew he was in trouble. And so at one point, he has a back and forth with Amy Coney Barrett, where Amy Coney Barrett is completely against him. He thinks it's a life preserver, but it's really an anvil that hits him in the head. She says, I understand you're using a statutory construction interpretation of the International Economic Emergency Powers Act, IEPA. And you say that the power that the president has to tariff in this area is because he has Article 2 powers, right? Article 2 powers around foreign affairs, and in combination, there's there's one word in particular that you like in IEPA, the word regulate, and that he can regulate by way of a tariff. There's also the word license, because that regulation is supposed to be in the form of a license or something similar. Why aren't you arguing that the tariff is a license? Because it was never argued in the brief. And he said, oh, you're right. I could make that argument. In fact, here's the clip.
This kind of goes back to Justice Kavanaugh's point. Algonquin rejects the idea that it was impermissible to use the fees, and we can call them, license fees that functioned as tariffs or duties in that case, whatever. But Algonquin said that Congress could use the exaction of money to control quantity. And I hear what you're saying is you can control quantity by numbers by imposing hard limits, but not by money. But that's not what Algonquin said. So I guess,
no.
Why?
Well, and I don't mean to suggest that you can't use exactions to control quantity. What I think Algonquin just shows the importance of context. It might be perfectly natural to read a phrase like adjust imports in the context of a statute that talks about tariffs, in the context of the Trade Expansion Act that has all sorts of provisions about tariffs and about the president adjusting tariff rates. It might be perfectly natural in that context to read a phrase like adjust the imports to be referring to changing tariff rates. It's just as unnatural to read a phrase like regulate importation to discuss that when the statute has nothing to do with tariffs and doesn't otherwise mention tariffs at all.
And do you think imposing tariffs is do you think that just blocking all trade is a bigger deal than imposing a 1% tariff across the board?
I think it would be a huge deal. It is just a different kind of deal.
That actually does not help him. That was actually a fool's gold that was being offered by Amy Coney Barrett, because it can't possibly be a license because it's revenue generating, and she knows it. And so I think she laid a trap which he stepped right in the middle of. Now, again, we're looking for besides the 2.5 hours of oral argument that we covered here on Legal AF, we're looking for missteps. Now that we've had a chance to look at the full transcript, now that we've had a chance to listen to the video clips. And I think that blunder, and the New York Times picked it up too, is a major one, because they're not going to give him tariff power based on a lie. As I said in earlier commentary about this, when you're, and I've been before appellate panels and appellate judges before, you have to concede when you are in the wrong. You can't double down on it and say, tariffs, well, why aren't tariffs revenue generating? Well, it's incidental. It's really about policy and control. No, you have to say it's revenue generating, but that you're allowed to do it under the presidency because, and then make your argument. You can't say out loud that the sky isn't blue and the grass isn't green. You have to explain why the grass being green and the sky being blue is okay under your argument, and then explain it. Otherwise, you are inauthentic and you are a liar, and you get caught in that lie. And that's all you have is credibility as an advocate. Now, the only thing that gives me a little bit of pause, I'll end the hot take with here, is that the next day after the oral argument, which universally people think went poorly for the Trump administration and that they're going to lose their tariffs, there was like a little glimmer of hope for the Trump administration in an opinion that on its face looks like it's about transgender Americans and their ability to have a passport for gender match their self-identity. And they rejected that and said, no, you have to list what your assigned gender was at birth, 30 years, 20 years later on a foreign affairs facing document. And they talked about the power of the president in the area of foreign affairs. So that's where you're going to see the fight break out on the Supreme Court among the MAGA six. If Gorsuch and Roberts lean into the foreign affairs power of the president combined with IEPA, gives him a tariff. A tariff isn't a tax. A tariff is something else. A tariff is regulatory only. They're going to side with the others, and it's going to be 6-3 to keep the tariffs in place. If, however, they listen to the president and what the president has said in his filings, that this is revenue generating and tariff creating, and the tariffs create wealth, then they're going to strike it down. So we got to be careful, because I see reference to the foreign affairs power of the president reigning supreme in the ruling that came out a day after the decision or the oral argument. So, I'm managing expectations here. We'll continue to follow it all. Hit the free subscribe button. Thank you for being here on Friday. I'm Michael Popok. Slide over to Legal AF Substack, where you can read this brief for yourself that I just analyzed for you. So until my next report, I'm Michael Popok. I'm Michael Popok, and I got some big news for our audience. Most of you know me as the co-founder of Midas Touch's Legal AF and the Legal AF YouTube channel, or as a 35-year national trial lawyer. Now, building on what we started together on Legal AF, I've launched a new law firm, the Popok Firm, dedicated to obtaining justice through compassionate and zealous legal representation. At the Popok Firm, we are focused on obtaining justice for those who have been injured or damaged by a life-altering event, by securing the highest dollar recoveries. I've been tirelessly fighting for justice for the last 35 years, so my own law firm organically building on my Legal AF work just feels right. And I've handpicked a team of top-tier trial fighters and settlement experts throughout all 50 states known as big auto injury attorneys who have the know-how to beat heartless insurance companies, corporations, government entities, and their attorneys. Big Auto's attorneys working with my firm are rock stars in their respective states, and collectively responsible for billions of dollars in recoveries. So if you or a loved one have been on the wrong side of a catastrophic auto, motor vehicle, rideshare, or truck accident, suffered a personal injury, or been the victim of medical malpractice, employment harassment or discrimination, or suffered a violation of your civil and constitutional rights, then contact the Popok Firm today at 1-877-POPOK-AF or by visiting my website at www.thepopokfirm.com and fill out a free case evaluation form. And if we determine that you have a case and you sign with us, we don't get paid unless you do. The Popok Firm, fighting for your justice every step of the way.